All right, future CPAs, what's up? Let's get straight to it. We're not just cramming for some random quiz today. No, we are basically going to download this stuff directly into your brain for good. Think of this as your ultimate study hack for the LCPA, making sure these rules on partnership management stick around long enough for the actual boards, even if that's years away.
Okay, so to make this stuff actually make sense, let's imagine something. You and your friends, you finally do it. You launch that killer startup idea you've been talking about forever. The vibe is incredible, right? But then reality hits. Who's the boss when you can't agree? Who actually owns the laptop? What's your piece of the pie? I mean, these are the questions that can literally blow up friendships and kill a business before it even starts. Lucky for us, the law has a playbook for exactly this. All right, here's the game plan for today. We're going to break down a partner's 3 core rights. Then, we'll look at what happens when a manager's in the articles versus appointed later. We'll sort out what to do when managers disagree and what happens when no one's in charge. And then, we'll hit it with a final bullet review to lock it all in.
Okay, first things first, let's talk about a partner's 3 core rights. What do you actually own in a partnership? Because, spoiler alert, it's not as simple as saying, I own 20%. The law gets super specific here, and you've got to know the difference.
So everything comes down to the number 3. Seriously. Article 1810 says every single partner has exactly 3, count them, 3 fundamental property rights. Just burn that number into your brain. 3, it's the foundation for everything else we're about to cover.
And here they are. Your rights in specific partnership property, your interest in the partnership, and your right to participate in management. Now, that sounds kind of legalish, so let's simplify it. Think of it this way. What you can use, what you can earn, and what you can decide. You get to use the company's stuff, you get to earn your share of the profits, and you get a say in how to decide things. Use, earn, decide. Easy, right?
Okay, pay attention, because this slide right here, this is a goldmine for exam questions. It's all about the difference between property and your interest. So that office laptop, that's specific partnership property. Can you sell it on your own? Nope. Can your personal creditors seize it if you owe them money? Absolutely not. But your interest, your share of the profits, that's a whole different story. That's yours. You can totally sell it. And yeah, your creditors can definitely come after it. Nailing this distinction, that's how you get points on the board.
All right, next up, the in the articles manager. We're talking about the original boss, the one who was named manager from day one.
So check this out. Article 1800 says that if you're appointed manager in the Articles of Partnership, you can basically run the show, even if your partners are against it. Your authority is like baked into the company's DNA. The only thing that can stop you? Acting in bad faith. That's your only kryptonite. Okay, but what about the appointed later manager? This is like hiring a gun after the fight has already started. The partnership's already up and running, and then they decide, hey, maybe we need someone in charge. This changes everything. And here is a major LECPA hack, so listen up. It's all about revoking a manager's power. The manager appointed in the articles, think of them as having plot armor. They are super hard to get rid of. You need a just cause, like they did something really bad, and you need the vote of the partners with the controlling interest. But the manager who was appointed later? No plot armor. They can be fired at any time for any reason or no reason at all. All it takes is that controlling interest vote. Way easier.
Okay, so what if things get even more complicated? What if you have multiple managers and they get into a power struggle? They're totally deadlocked. What happens then?
Well, business can't just grind to a halt, right? So the law is ready for this. It gives us a super clear 2-step process to break that tie.
It's a simple 2-step process. Step 1, the majority rules. You just count the votes of the managing partners. Easy. But what happens if it's a tie? Well, that's step 2. In case of a tie, the decision goes to the partner, or partners, who own the controlling interest. So here's your memory hook. It's heads, then wallets. First, count the heads of the managers. If that doesn't work, follow the money.
Okay, last management scenario. What happens when no one is officially the manager? Like, they just started the business and never bothered to appoint anyone. Who's in charge then?
This brings us to a super important legal principle called mutual agency. Basically, this is the law's default setting. If the partners don't pick a manager, the law picks one for them. Or rather, it picks all of them.
Yeah, you heard me right. The rule is every partner is an agent of the partnership. So if nobody was appointed manager, guess what? Everyone is a manager.
Any partner can go out and sign a contract that binds the entire company. It's kind of like all for one, which sounds great, but it can also be a recipe for total chaos if you're not all on the same page.
Whew. Okay, we've covered a lot. So now it's time for the final boss, the LECPA Bullet Review. This is your high-yield cheat sheet. Seriously, screenshot this. Tattoo it on your arm. I don't care. Just get this into your brain.
All right, let's run through it one last time super fast. Your 3 rights: specific property which you can't sell or attach, your interest which you can sell and attach, and management. Remember, use, earn, decide. Manager in the articles has that plot armor. They're hard to remove. Manager appointed later, no plot armor. Easy to remove. If multiple managers disagree, it's the rule of the majority. Heads first. The tiebreaker, the partner with a controlling interest decides. Wallet second. And if there's no manager, everyone's an agent. That's mutual agency. That's it. That's the playbook.
So there you have it. You know the rules now. And knowing this playbook is critical for crushing the LECPA, for sure. But here's the real takeaway. The law gives you the rules for when things go wrong, but it can't make you pick the right partners in the first place. Knowing the rules is one thing, but knowing who to go into business with, that's the real test. All right, good luck with your review.